This is the Wizard News. In courtrooms around Illinois after September 18, 2023, judges conducted the first hearings under a new system that determines whether a defendant will be jailed while awaiting trial based on dangerousness and risk of fleeing a prosecution rather than their ability to post bail. The abolition of cash bail was included in the Safety Act Criminal Justice Reform of 2021 and originally slated to take effect January 1st, though court challenges delayed its implementation. In Clair County Circuit Court, where nearly 2,000 felony cases and more than 3,400 misdemeanors are filed annually, at least one person was released from jail to await trial on the second day the Safety Act's bail reform provisions were in effect. The new law entitled defendants held in lieu of bail prior to the September 18, 2023 effective date to petition to have their cases moved to the new system. The hearings resembled detention hearings held in federal court, which has not used cash bail as a detention method since 1984, with testimony focusing on whether the person is a flight risk or a danger to the public or a specific person. Bond hearings have historically been quick affairs, often with no defense attorneys present for indigent defendants who would not get assigned a public defender until later in their case. But detention hearings in Clair County on the Monday afternoon of September 18, 2023 took about 15 minutes each. Both the state's attorney and the public defender assigned to handle the week's hearings laid out their cases for whether the defendant should continue to be held in Clair County Jail or released. All parties and the judge also had access to the defendant's criminal history, a practice that is not new in either Clair or St. Clair County courts, but is a novel development in many counties that have been working with the Office of Statewide Pretrial Services, which has been staffing up to compile those reports for the better part of a year. 2 murder suspects in St. Clair County were found ineligible for release and held until trial. Judge John O'Gara told the defendants that they had the right to appeal his decisions and, if they could not afford an attorney, a public defender would be appointed for them. St. Clair County Public Defender Kathy McElroy filed motions for detention hearings under the Safety Act for all the clients she represents who were jailed in lieu of bail prior to Monday. She anticipates there will be hundreds of hearings in the coming month. It's day 1, and I can already see that I will need more help, McElroy said. In addition to the detention hearings, defendants that are detained must be tried within 90 days, 30 days shorter than the previous 120-day speedy trial requirement. Extensions requested by the defense do not count against that time frame. St. Clair County Chief Judge Andrew Gleason said that he expects more hearings and that he set aside a courtroom for those hearings and reassigned a judge from traffic and misdemeanor court to preside over detention hearings. The Safety Act was a response to the cash bail system, which the U.S. Commission on Civil Rights found disproportionately impacts minorities. The random alcohol testing order is an example of a condition Kane County Chief Judge Clint Hall said he expected to see less frequently under the Safety Act, given the law's mandate that defendants be placed under the least restrictive conditions necessary while still ensuring they show up to court. While Ho said he's heard concerns from law enforcement predicting fewer opportunities to reach those who may need drug or alcohol treatment, he said he understands one of the Safety Act's many goals is to limit judges giving conditions just for conditions' sake. This is the biggest criminal justice change since the code was written in 1963. So there's a lot of things that we don't know, Howell said. A misdemeanor domestic battery charge, one of the so-called detainable offenses laid out under the new law, is the type of case Ho predicted would be the most common to appear in detention hearings. Source: Capital News, Illinois, September 19, 2023.